hope I'll trouble you only for 5 minutes, just on that question of what we're asking you, the court, to do in relation to EP Albania. My Lord, it's in the skeleton argument, paragraph 64 to 65, and what that says, and it may not be necessary to turn it up, but just in summary, what is being challenged is paragraphs 149 to 150 of the tribunal's determination.
Yeah, in other words, that was the bit which applied to your client.
Which applied to my client. So, for absolute clarity, and I may have said something misleading or unclear, I should say, in earlier, we're not seeking in this appeal to challenge the general guidance. That's not how it's been put. The reason I took you to it was simply to show the sorts of reasons why this kind of decision ought to be amenable to challenge, but I'm not in this case.
What you are in fact challenging are 149
to 150.
To 150.
That is what's challenged, and that's paragraph 64 to 65. There is reference to the earlier generic bits, but just by way of showing that there are additional exceptions, as it were. There are examples of where consent would not be determinative. So it's not a challenge to that guidance. And so, and then the second point that arises out of that is why do we say, even though the argument may not have been as clearly put before the tribunal as it is now put in the skeleton argument, for which permission was granted by Lady Justice Elizabeth Lang, why do we still say EP Albania is wrong? Because, and the reason for that is that it obviously, as a matter of fact, it is now conceded that the judge was wrong to dispense with an oral hearing. That's Upper Tribunal Judge McClellan. And fairness is an objective question. That's the Supreme Court in Osborne. Just to give you the citation, I'm afraid I don't have it with me, but it's not a controversial proposition. 2014, appeals cases 1115, and it's paragraph 65. The question of fairness is not a reviewing, it's not a review jurisdiction. It's an objective question, and the court must decide itself whether a fair procedure has been followed. So on an appeal, on a challenge, our case is the tribunal got it wrong. The fact that the arguments could have been put more clearly is neither here nor there. It was wrong to conclude that it was fair. That was the question before it under Rule 43. Was there or wasn't there a procedural irregularity? There wasn't a procedural irregularity. Sorry, there was a procedural irregularity. That's now conceded. So the tribunal was wrong. It's a yes and no answer. There's no, well, it was right on what was before it. That's not the issue.
Why not?
Well,
how
because
on
it's a
earth
fairness.
Is a tribunal to know upon what basis a case is put to it on, as you would have had said yesterday, or whenever the decision of EP was being dealt with, it is not fair because you are saying that the tribunal said, well, it is fair because of that, but we can think of other reasons that you haven't mentioned before us.
Well, there are two separate questions: whether the tribunal went wrong on what was before it.
Well, on what was before it, and we've looked at the skeleton argument, it is at least arguable that it was a completely different case to that which you now hang your coat on.
Well, I certainly accept it wasn't put as clearly. I don't accept that the point was not raised, although not as clearly in front of the tribunal.
Do you say it was raised in the skeleton argument that you referred us to in paragraph 11? Is that what you base your submission upon?
Sorry, the skeleton I've just referred you to is our skeleton in this appeal.
I'm talking about the skeleton
the
argument
original
you took
appeal.
us to
It
just
was not
before the
raised
short
as,
adjournment.
it was not raised squarely in the way it is raised before this court.
Is it raised in any way?
Well,
not among squarely.
What is raised is that there was just the issue of the Secretary of State's lack of opposition to the case that was put before the first tier tribunal. So in other words...
Well, hang on a second. What you showed us in paragraph 11 was actually introduced by an indication that the appellant had been told that he'd got a good prospect of success. And the reason for that view was that it had already successfully appealed an FTT determination to the UT once before, and you say why he'd been successful, and permission had been granted to appeal the determination on all grounds. In light of these factors, it was reasonable to be confident that a UT judge determining the appeal would be likely to grant the appeal. That's nonsense. Permission does not indicate that an appeal will succeed.
Well, my lady, I accept that, but I'm simply referring to the fact that he had, there had not been any challenge from the Secretary of State. I mean, I can't say more than that the point was raised that this was an unchallenged.
Well, show us in paragraph 11 or 12 where it says that the Secretary of State had not challenged the appeal that was to be made. The challenge that was not made was in relation to
It's not in the skeleton, and there was oral argument at the hearing. I don't have the transcript, but my lady, the main point here is that this is an objective question. Of course, the Secretary of State did not consent to this determination being set aside until this appeal had already been brought in this court. So the question was, should this appeal have been set aside? And the answer that is now given is yes. That is an objective question.
Before EP.
It was the Secretary of State in EP took a sort of a hybrid position, which was that she did not oppose. She did not oppose the setting aside, but she did not consent to it either. So there was no consent order.
Sorry, in which case?
In EP Albania.
In EP itself?
In EP Albania before the tribunal, as you will, it's a very long determination, but just the procedural background, and it's one reason why the arguments were perhaps not fleshed out as well as they might have been, is that in advance of the EP Albania hearing, the Secretary of State produced a skeleton argument. My Lord Justice Dingemans may recall this, in which she said, I agree that on application, people's appeals should be set aside. Anyone who has been through this unlawful procedure, unless there are exceptional circumstances. So that was the Secretary of State's position in front of the tribunal. It wasn't until...
And the judges didn't accept that?
The judges did not accept that, but it wasn't apparent until the hearing itself that the judges were not going to accept the Secretary of the position between the parties. And so what then happened is that people were, and this is a fair observation to make, having thought it was going to be straightforward, and everyone did, because the Secretary of State was not opposing set aside, not consenting to it directly, but equally not opposing it. And she had been asked to consent to it, and the tribunal referred to that, the fact that she did not produce consent orders. People were then required to start explaining on their feet, effectively, elaborating on why on the facts of their cases it was unfair. And so there was a lot of oral argument. That the hearing went over from, it was supposed to be listed for 2 days, it ended up being relisted for the 29th of June, with people being, having to respond on their feet to what was not anticipated to be a contested hearing, effectively. So I just say that because it is partially relevant, in my respectful submission, to why these arguments have ended up being fleshed out more on appeal than they were in front of the tribunal. But it's also the case that the Secretary of State did not consent to the setting aside, and so, but has now agreed that it was wrong to dispense with an oral hearing. Now,
well, if the argument was advanced orally for the upper tribunal in the sort of terms in which it was put to Lady Justice Lang, it's odd that it didn't find its way into the tribunal's determination.
I don't say it was advanced orally. What I say is simply that there wasn't, because people were having to deal with things, and it wasn't just my learned junior who was then representing the appellant who was being put in that position. All the appellants were having to respond to argument, having to explain on their feet what had gone wrong in response to concerns raised by the tribunal at the hearing, which had not been raised by the Secretary of State, because the Secretary of State did not put in any submissions on the facts. So that is one explanation. But my main point is which is as the Osborne point, fairness is an objective question. The tribunal was being asked to decide whether or not it was fair to to dispense with an oral hearing, whether there had been, as a matter of law, a procedural irregularity, and the tribunal concluded that there hadn't been a procedural irregularity in circumstances where it is now accepted that there was. And it's that simple point. It was wrong. The tribunal was wrong.
Yeah, I mean, you say it's conceded, but I'm not sure that it has been.
Well, it's in the statement of reasons.
Well, the statement of reasons says that the Secretary of State accept the FTT erred in not engaging adequately with the expert evidence. UT erred in its assessment.
No,
Oh, I see. And the appellant's need for a hearing.
Yes, 12, paragraph 12.
Yeah. Yes.
Suppose we don't agree with that, on the basis that we prefer the determination of EP on the basis of the case put before them.
Well, my lord,
It seems
my lady,
strange that the SS should, as it were, determine the issue on a completely different basis.
Well, my lady, the appellant has permission on the basis, on the arguments that have been put today, which are concern the objective question, whether it was fair or not, which, as I've said, in Osborne in the Supreme Court, the court said it's not a review jurisdiction, it's an objective question. Was it or wasn't it fair?
Yeah, I
And
understand
so
that.
on that basis, I have not, it has been conceded on that basis. I've not argued before you the consent point because it's conceded. If you would like me to do that, I will have to ask for more time to do it.
No, I'd like you, please, though, to very quickly, because you must have looked at it, I should think, over the short adjournment, given the discussion that's been going on with the court about CPR 52.22 1.1, which is about raising a new point on appeal that wasn't in the court below or the tribunal below. It's not verboten, but it's usual to be straightforward about it and say this is the reason why you should hear it.
Well, 22, 52, 22.
1.1.
I may have an old version of that in my, so I'll have to look. I haven't looked at that, but it may be that the most convenient way to deal with this is for me to look at this in reply. But I say again, this is a question of law. The court had an obligation to decide for itself whether it was fair to proceed without an oral hearing. That's Rule 34.
Sorry to interrupt you, Ms. Carver. I don't see that point taken in the skeleton argument in the appeal to the upper tribunal, first appeal to the upper tribunal. There are a number of complaints about not engaging with the evidence and so forth. I don't think that in the skeleton it said that the very idea of having no oral hearing was itself unfair, so the upper tribunal Judge McLennan wasn't asked to consider that point.
No, but that's the whole point here, because the appellant had been asked in directions to agree to indicate its position on whether to hold an oral hearing or not. And the appellant had said that it agreed to a paper determination. So obviously it wasn't dealt with in the skeleton argument at that point.
Oh, I see.
That's the whole basis on which we've got permission,
Yeah.
which is that the court has accepted, as the tribunal did in EP Albania, that under Rule 34, when the court decides what procedure it follows, it has to decide for itself whether it's fair. And the court was in possession of information which the appellant was not in possession of when the court came to make that final assessment at the time it reached its determination. So no, it wasn't raised in the skeleton argument. Now, it's now raised on appeal. Now, funnily enough, the question my lady asked is also relevant to and the reason I laughed a little is it's relevant to the jurisdiction point, because the set-aside application is an application to ask the tribunal to set aside the determination. But it's not a right of appeal. It's not the right of appeal. There is an application for appeal, separate. There's no doubt about that. A separate application seeking permission to appeal, which has been granted on this ground. Ground 4 is squarely against the determination of Upper Tribunal Judge McClellan. So there's no question there of not having raised the point in front of EP Albania, precluding the appellant from raising it on the substantive appeal. It's an additional avenue. My lord, unless there's anything else I can assist with, my lady.
Thank you very much, Ms. Kilroy. Yes, Mr. Harland.
My lord asked for a respondent's notice.
Yes, please.
I hand this up.
Yep. Has Ms. Kilroy seen it?
She has.
Yeah, and you'll undertake to serve it properly and pay any fee and all that.
My lord, yes. Can I say this? Miss Kilroy, fairly to her, objects to the wording of paragraph 1, and in that, and perhaps in only that, she agrees with Mr. Waite, who's my predecessor in this matter, because she says that what we're not seeking to do when we raise a jurisdictional point is uphold the decision of the tribunal EP on an additional basis, because we're saying not that EP was right for these reasons, but rather that this court simply doesn't have jurisdiction to look at EP, and therefore we shouldn't be phrasing the respondent's notice in the way that we have. The reality is we phrase the respondent's notice in the way we have because that is the way that the CPR phrase it in 52.13. A respondent's notice, of course, is discretionary, should only be filed if the respondent seeks to persuade the court to uphold the lower court's decision on a different or additional basis. And that is why Mr. Waite perhaps agrees with Ms. Kilroy on the basis that a respondent's notice just to take a jurisdictional issue is not necessarily required. Now, my lord, I don't dispute that it obviously helps everyone for the respondent's case to be set out. It has been set out in the skeleton argument, but we set it out again here, hopefully more clearly, so that Ms. Kilroy in particular can understand what our point is on relation to the appeal. Whilst we're on this, I may as well summarise it very quickly. Paragraph 2 says, takes a jurisdiction point. Paragraph 3 says that in any event, even if it's not for the jurisdiction point, then the merits of we say paragraphs 149 to 50 of EP is wholly academic because it's going to go back to the first tier tribunal. But at paragraph 4 we set out our case, and I hope it's not put too nicely, but we say this: we don't accept, we haven't conceded and do not accept that 149 to 50 of EP Albania were wrongly decided on the facts of the wrongly applied to the facts of the appellant's case, notwithstanding our concession in this statement of reasons which we've supplied in this appeal. And there is a distinction, because we can of course say there should have been a rehearing, but we can also accept, we can also not concede that EP reached the wrong decision on the basis of the arguments put before it. And we say that is a matter for Ms. Kilroy and her team to show. Like I say, I hope I'm not trying to be too nice on that distinction. That is the Secretary of State's position. My Lord, what I intend to do, and I'm aware of the time already, is this. I want to start off by setting out the background, why we say that in the context of Rule 43 decisions, there was no intention to create an appeal right. And then I go on to say, was the Lord Chancellor entitled to exclude Rule 43 decisions. That's the Vires argument. In relation to the first of those, we say it's clear from the explanatory memorandum and the structure of the rules that there was no expectation that Rule 43 would carry an appeal right. In relation to the second of those, we say with respect that the appellant has simply misunderstood the purpose of section of 13(9)(b). There is a reason for that provision, and I'll hopefully try and explain it in due course, but it's not to try and somehow mean that Rule 43 decisions accidentally get a right of appeal. And then the third area is really whether the Lord Chancellor did in fact exclude Rule 43 decisions when he made the order, ADO order, excluding procedural ancillary decisions. So starting off with the first of those, my Lord, it's unfortunate that the explanatory memorandum is cut off, and I don't know if that's been rectified over lunch, but Ms Kilroy fairly took your Lordships and your Ladyship to that, to the explanatory memorandum. And just to read it out in full again, paragraph 115. So I have this, I had written in the pagination on the pages, but it's the 7th page in the bundle that I have, and it's the page which is in landscape. And at paragraph 115, it sets out the two purposes of subsection 9 of section 13. And you'll understand from my skeleton argument that I'm setting out the context here, which is that the Lord Chancellor has been given the permission by order to exclude decisions from appeal. And so there have to be some constraints on that. And the constraints are those in 13.9. But the explanatory notes say this. The first purpose is the preservation of existing appeal rights, where those rights are or include something other than a right of appeal on a point of law. Well, that's irrelevant to us here. We all agreed there were no pre-existing appeal rights. But it goes on to say the second purpose is the preservation in cases where there isn't currently no appeal right of the existing position. And that is the case here. There were no pre-existing appeal rights. What one would expect from the explanatory notes is that the status quo is preserved. But as the appellant would have it, the reality is that under section 13, an appeal right in relation to Rule 43 was accidentally created and couldn't be curtailed, because she would say, Ms Kilroy would say, that because the appeal right didn't exist before, it can't be excluded. And we say that's the wrong way around of looking at it. The explanatory note is clear that the status quo is intended to be preserved. That takes us on to the Social Security Commissioner's procedure regulations, which are at page 17 of the bundle, 17 in my bundle. They're described as page 18 on the index.
Yeah.
Now, the purpose of referring to this provision is to make this point. The draftsman who was preparing the TCEA must have been familiar with the provisions in relation to set aside on procedural grounds which existed in some tribunals prior to the TCEA coming into force. And so here, for example, we have the Social Security Commissioner's Procedure Regulations, and at 31(1)(a) and B, one sees that this is almost in identical terms to the Rule 43 power to set aside on basic procedural grounds. And if one turns over the page, one sees there at Regulation 32, it says at 32.2, there shall be no appeal against a correction or refusal to correct under Regulation 30 or a determination given under Regulation 31. And the point, therefore, that we're making is that the provisions from which the words that became Rule 43 are borrowed from didn't have a right of appeal before the TCEA. And so the draftsman to the TCEA would have been alive to the fact that this power existed for procedural reasons. He'd have been alive to the fact that it had no right of appeal. And he doesn't provide for a right of appeal down the line. What the explanatory notes say is the status quo should be preserved. And the status quo in relation to such provisions was no right of appeal. And it doesn't fit.
I mean, you say that Rule 43 borrows these words. I mean, more to the point, I think, it's paragraph 15 of Schedule 5 which borrows those words. But then it will no doubt be said against you, well, paragraph 15 of Schedule 5 borrows the words of Rule 31 of the regulations, but not 32.
Well, look, yes, but that would be the case if there were no right of if there was a right of appeal prior to that. One could see what the intention would have. Had there been a right of appeal prior to that, one could see what the intention was. But the explanatory notes tie together with the TCA and the terms of Section 15, Schedule 5 are clearly, we say, not anticipating a right of appeal. And of course, it's true that in the TCA itself, the set-aside power under Schedule 5, Section 15 isn't specified as being an excluded decision. But there was, in fact, no lacuna, because what we know is that as soon as the upper tribunal came into existence, it was also given, if my argument is right, at the very same time, the procedural and ancillary and preliminary powers were also excluded.
So I think your point then is that if there is a right of appeal under Rule 43 of the against the upper tribunal in immigration cases, it must also follow that there is a right of appeal in social security cases.
No,
is that the point?
I accept the observation that my learned friend made, and I'll come back to it later, where she said, no, these are different functions. There's an appeal, there's the immigration function and the social security function, and that different tribunals may have different rules of procedure. The point of drawing this court's attention to these rules is to simply make the observation that this was not a novel power which had never been encountered in this jurisdiction before, in this legal jurisdiction. The English law had encountered a power to set aside on procedural grounds previously, but when it did, that power had no right of appeal. So the status quo, therefore, would persevere. The next point I intended to make in relation to what one can tell about the expectation at the time is by looking at the structure of the rules. Because if one looks at Part 7 of the rules, which is at page 24 of the authorities bundle, course, these are effectively set out in Schedule 5, Section 15. One can see here, pretty clearly set out, what is in the draftsman's mind.
We're
Sorry.
looking now at Part 7.
At Part 7 of the Upper Tribunal Rules. So it's at page 24. It has a pagination of 32 at the bottom of the page and Part 7 at the top of it. But it's the pages that we have in the bundle dealing with the Upper Tribunal Rules.
Thank you.
And we can see here, Part 7 is described correcting, setting aside, reviewing and appealing decisions of the Upper Tribunal. And the point that is made in our skeleton argument is that these are 4 different routes to try and rectify something that has gone wrong. But they are 4 different routes. And it is not the case that the structure of Part 7 makes the set aside or the slip rule or even the review subsidiary to the appeal route. So one can see at 42 clerical mistakes and accidental slips or omissions, 43 setting aside a decision which disposes of proceedings, 44 the application for permission to appeal, and then within that application for permission to appeal you have the right, the power to review the decision under 46. So these are different ways of getting to the right conclusion, but just as the slip rule is meant to be a straightforward procedure for correcting mistake, so the setting aside procedure is intended to be a way of correcting mistake without having to go through the Rule 44 procedure of appealing. And at that point, my lords, my lady, one would turn up the paragraph of the rules which was handed up this morning.
Can I just ask you before we go there
Yes.
about paragraph 48,
Yes.
which seems to contemplate you might apply for a review under paragraph 40, set aside under Rule 43. The tribunal can treat it as an application for permission to appeal, deal with it on that basis, and if you are turned down by the upper tribunal, you would you have a right to come to this court for permission?
That was quite close to the factual circumstance of the AVB case, which is in the authorities bundle, which was cited, in which the upper tribunal judge did treat it, an application to set aside as an application for permission to appeal, and the Secretary of State's position, and refused it. And the Secretary of State's position was, in that case, well, the appellant has the right to appeal further up in line with the statutory appeal, so that they can bring the appeal under 44 to the Court of Appeal and see if they can persuade this court that there was something wrong of substance in the decision.
Right. So these routes are not in hermetically sealed boxes.
No.
You can go from one to the other, but the tribunal's got to decide
Yes.
that you should be treated as an application for permission to appeal rather than as a Rule 43 reopening.
My lord, yes, and in a way that supports my argument rather than hinders it, insofar as these are still distinct routes, and so a tribunal can say, well, I'm sorry, I understand what you think you're applying for, but actually I'm going to treat it as this instead. And that, again, reiterates this idea that the set-aside is different conceptually to the appeal.
Right. You wanted us to look at something you handed up.
I had it up, and it wasn't in the bundle. I hadn't appreciated it might be...
Rule 40.
Yes, Rule 40. And the point is made in the skeleton argument that there are provisions which are in place to facilitate the appeal against decisions which finally dispose of an appeal. So this is Rule 40, and Rule 42, one can see there at 42B, relates to notification of any right of review or time limit for appeal. But one can see from the text of 42 that that doesn't apply to decisions under Part 7, which are the ones which we've been looking at. So what that means is that if there's a decision to set aside, not to set aside, you don't need to inform the applicant for set aside of any appeal rights. And more than that, if one goes on to 43A, that is the provision which requires written reasons for a decision. And again, it doesn't apply to Part 7 decisions. And so under the structure of the rules, a decision to set aside or not to set aside does not require you to notify anyone of rights to appeal or even provide written reasons which would allow you to challenge that.
Sorry,
So we say that isn't...
Where's that column? 3?
So under 43.
The tribunal must provide written reasons for its decision.
So sorry, my lord, I'm simply, I'm just checking, because I had it up, the sheets before, and I'm just checking that I have them now.
With a decision notice provided under paragraph 2A, unless a decision was made with consent of the parties, or the parties have consented to the upper tribunal. Why does that not apply to Part 7?
So if one looks at 40 and then 2.
40, sub-rule 2.
Yes, it says there, the upper tribunal must provide to each party as soon as reasonably practicable after making a decision, and then in brackets, other than a decision under Part 7, which finally disposes of all
Oh, I
issues
see.
and
So it's
proceedings.
because you haven't got to provide the decision notice.
Yes. And then at 3, it talks about the upper tribunal must provide written reasons for its decisions with a decision notice provided under paragraph 2A.
I see. As you don't have to provide a decision notice under 2A,
You don't
you
have.
don't have to provide it.
So it doesn't look like the construction of the upper tribunal rules intended there to be a appeal against them, because had there been, one would have anticipated that notice of rights of appeal would be given, and there would be a requirement for someone to give reasons so that they could be understood and challenged. Whilst we're on the upper tribunal rules, can I take your lordships and your ladyship to, and we're back in the bundle now, to rule 44, my page 25, but it's got pagination 33 at the bottom of it. One can see at the bottom of this page, at 44.4, this is in relation to the time limits for appealing. And 44.4 sets out when the time starts to run. It runs from 1 month after the latest of the dates below. And the first date is the written reasons for the decision. The second date is notification of amended reasons for correction of the decision following a review. But the third, 44.4c, is notification that an application for the decision to be set aside has been unsuccessful. And the reason why I take the court to that section is because it may be an answer to Ms. Kilroy's point in relation to the difficulties that people might find themselves in relation to permission to appeal. Because what it looks like here is that the upper tribunal rules have built in a provision so that what you can do is apply for a set aside, and if you're knocked back from that, then you have a 1 month which runs from the date when you're refused your application to set aside in order to bring your appeal. And again, what that suggests is that the set aside is seen as a different concept to the appeal. But what you can do is, once you've been refused your application to set aside, you can then potentially reuse the same procedural arguments. You can say, for example, there was an error of law because I wasn't permitted to attend, I wasn't able to attend my hearing. But you have to put that into your substantive appeal against the substantive decision to say that it was wrong. So you've tried to go down the shortcut, it's closed to you, you have to go the long way around.
And is there any jurisprudence about set-asides and what they're intended to achieve?
Neither party seems to have found much. There are cases, of course, in the authorities bundle which seem to deal with some of these points. The case of AVB, which the Secretary of State has raised and in the skeleton argument says was wrongly decided in the High Court, that did deal to some degree with excluded decisions and set aside. But there doesn't seem to be jurisprudence in relation to this, perhaps because it hasn't become too much of an issue.
Can I just ask you about MO Nigeria, which Ms Kilroy was explaining to us this morning? What she said was that they were out of time for an appeal, but the upper tribunal extended time so they could make their Rule 43 application. Do I understand you to say that if the upper tribunal were to extend time for the making of a Rule 43 application, then, so to speak, time would run again for the purposes of an appeal, because under Rule 44, Sub-Rule 4, you still have a month after your Rule 43 application fails in which to ask for permission to appeal? Is that how it works?
I hesitate because I don't have instructions on this and I'm not familiar with the facts.
Well, never mind about facts. Take a hypothetical case. Somebody is out of time for as it were, a plain vanilla appeal under Rule 44, application for permission under Rule 44, but gets an extension of time within which to apply under Rule 43. I think from what you've just been showing us, if that were to happen, then time for applying for permission to appeal would, so to speak, start again, and you'd get a month from the refusal of the Rule 43 application in which to apply for permission to appeal.
My Lord, I can sense judges who have the tribunal jumping up and down behind me, urging me to be cautious.
They would never do anything so undignified.
In what I would say. But certainly the format of the rules suggests that the purpose is to allow that extra appeal after the set-aside has been refused. So that would tally.
Well, if that's right, then the mismatch that Ms Kilroy points to doesn't really exist.
Well, that's why I was struggling to understand it earlier, and were I instructed in MO, then perhaps I understand her difficulties in that case better. But I must admit, the particular problem which has arisen in that case must be capable, in my respectful submission, of some kind of resolution which does not involve conjuring up a right of appeal against Rule 43 decisions. It may be that there can be an extension of time off the basis of this provision. It may be that there can be an extension of time by this court. It may be that in certain circumstances a challenge can be brought by way of judicial review. But I do say it didn't seem to me an insurmountable problem when it was being described.
Your construction of 44.4c would mean that you're out of time for permission to appeal. You then send off an application for Rule 43. The tribunal looks at it and says you're out of time and these grounds are hopeless. And then you can start with a month to go to the to the Court of Appeal, because that's notification that an application for the decision to be set aside has been unsuccessful. It doesn't say had to be admitted and then was unsuccessful. So I suspect that's the reason why you're right in saying that upper tribunal judges might be concerned about such a construction.
Yes, well, my Lord, I didn't intend to have an exhaustive analysis of these provisions, but solely to point to
to make the point that it does have, in certain circumstances yet to be defined, a chance to extend time.
Yes, or at least in an ordinary case, it appears. ordinary being where someone has applied within time to set aside, and then that has been refused, then they will have the ability then to apply under 44.1 for permission to appeal. And the point I was making is, in relation to the shortcut being closed off, you then need to go the long way round. Perhaps the reason, my lord, why there isn't significant jurisprudence on this is because it isn't particularly necessary. It doesn't add much to try and appeal the set-aside finding, because by that time you're on your route, if you can make it, to the appeal court in any event, and you may as well put together your argument as to why the upper tribunal, first tribunal erred in law, including your procedural reasons why there was an error of law, and proceed on your way. The point that was being made behind me is that in MO there is a pending judicial review in that case. It was because I think I'd raised the point about there being other routes of challenge. Yes, it's a pending judicial review on the same point, which has been stayed behind her appeal.
Of course, I mean, Rule 43 and permission to appeal don't overlap. I mean, you may say, well, a document wasn't sent to me. The tribunal may say, well, that's true, but it doesn't make any difference.
Yes.
Query whether there's any error of law there on which you could possibly get permission to appeal.
Yes, my lord, yes. And so, of course, there are going to be some circumstances where the lower threshold in 43 might be triggered by a judge who says, yes, it's in the interest of justice that we set this aside and start again. But in reality, if a judge isn't prepared to go down what I say is that procedural shortcut route, then the claimant or would-be appellant is going to have to go the long way round and persuade a higher court that there's been an error of law.
Why do you say the long way round? Do you really mean the more difficult route rather than the long way round? Because to seek permission to appeal against a substantive decision requires that the appellant establishes an arguable case, that it is likely to succeed, or some other compelling reason.
Well, my lady, in a way, it's a reference to the phrase which is now going to continue cropping up in this appeal about a quick and dirty route, insofar as there are, under Part 7, there are different, what I've called shortcuts, but different ways by which the tribunal
Yes, which is why I say, do you really mean not the long distance way around, but the more difficult option for an appellant?
My lady, yes. And so far as I was resisting that, it was only in that more difficult might seem somehow unfair, but in fact, it's not a more difficult route, it's just a standard route of appeal. The statutory route, the normal way to show that something has gone wrong.
I'm not suggesting anything other. One can't blame a would-be appellant from saying, well, this is going to be far easier to get a new hearing than going before a court of appeal, because all I've got to say to the upper tribunal is that the X was missing, and it's in the interests of justice that it at least should be considered.
Yes.
And as you said, there's a lower threshold, so there doesn't need to be any reasons given by the upper tribunal. They just say, yep, we're going to set aside. That's it.
Yes.
So
Lady,
that's far more straightforward, if you like.
my lady, yes. I don't intend to impute any blame on someone who takes that route. It's obviously the right route, and indeed it's one which everyone would endorse as being a way to avoid this court's resources being taken up unnecessarily.
But you're then saying that if it doesn't succeed, then it's not for the appellant to say, oh, I want to appeal the fact that Rule 43 wasn't used. They've got to go and say, okay, then I've got to go to the court on the substantive argument that there's been an error of law.
My lady, yes, because otherwise what was a lower threshold but an easier route becomes just as fraught with delay and difficulty, and it becomes resource intensive in the way that the straightforward appeal route would otherwise be. So yes, the purpose of it is it's a quick route, it looks at procedure, and I'm going to come on to say it's a procedural safeguard. It just is looking to see when procedure has gone wrong. I'm aware of the time.
So that's the structure of the rules, is it?
That was the structure of the rules.
And then you say that the appellant misunderstands 13.9b.
Yes. And I say that for this reason. Perhaps we can turn up 13.9b in the authorities binding, which is on the 5th page of the bundle. Now, my learned friend, and I hope I'm being fair to her submission, says in effect this: because there wasn't a power to set aside prior to TCA coming into force, then the power to set aside could not be validly excluded as a decision, because it was a new power with no rights of appeal against it previously. And what we say is that if that is the correct interpretation, it's wrong, or it's very odd. It's odd.
If it's the correct interpretation, how can it be wrong?
So if that were the correct interpretation, it's odd. And we say it's odd for these reasons. The first is that it would mean that for any new power created for the tribunal, not only a new appeal right created by accident, but the Lord Chancellor doesn't have the power under the order to then rectify that issue and exclude them. And we say that would be completely contrary to the explanatory notes that I took the court to earlier. And the second reason why the interpretation would be odd is this: it makes the wording unnecessarily complex. The same effect could be reached if it were said, for example, that decisions of that description are made in carrying out a power against which there was not previously any right to appeal. We wouldn't have to have the somewhat odd phrasing of talking about a function transferred under section 30. And I say that because that phrasing, one can see, a function transferred under section 30, is not only there in 9b, but it's also there in 10b and so on. It seems to be a phrase that the draftsman is focusing on. So was the decision, in this case, under Rule 43, taken in carrying out a function transferred under section 30, if we're looking at precisely that phrase?
Well, I wonder if that is the right question. What we're concerned with in section 13.9, or in fact 13.8f and 9, is a decision that is of a description specified in an order. And the order does not specify as a description the setting aside of previous decisions. It talks about procedural, ancillary, and whatever the other word is, decisions.
Yes.
So that's the description of the kind of decision. So then you ask yourself, well, was it a decision of that description, that is to say procedural, ancillary, and blah, blah, made in carrying out a function which has been transferred? And if it was, then you ask yourself, was there a right, was there previously, before the transfer, a right of appeal from decisions of that description?
Yes.
So it's the description that we're concerned with.
My Lord, I see that, and I can agree entirely with that reasoning and that logic. And the description here, we say, does cover the decisions under Rule 40.
Yeah, well, that's another point of disagreement between you, but...
Can I make this point in relation to what functions transferred under Section 30 mean? Because, as my learned friend observed earlier, the function of the Immigration Tribunal, in this respect at least, is determining immigration appeals. That is a different function to, for example, the Social Security Tribunal, which has a function of determining social security issues. And when one looks at, therefore, at functions, one is looking we would submit at a relatively broad description of the kind of things that the tribunal is interested in. So it doesn't, for example, mean something as narrow as powers. We say that in relation in the skeleton argument because we make the observation that the TCA at section 25.2 talks about powers which are expressly incidental to the upper tribunal's functions. And it would make no sense, really, to say that the upper tribunal's function in these circumstances is to take a Rule 43 decision. That isn't the upper tribunal's function. The upper tribunal's function is to determine an immigration or asylum appeal fairly.
Can I summarise that submission just to make sure I've got it accurately? So you're saying that decisions of that description we cross out and just write Rule 43, and then are made in carrying out a function transferred under Section 30, we cross out and put in hearing appeals from first-tier tribunals. And prior to the transfer of that function, there was no right of appeal from Rule 43.
My Lord, yes. And once one puts it in that way, there can be no doubt that these decisions fall under that description. But I say that...
And so where in Section 30, I mean, I've seen the structure of 30, but what particular wording provision do you rely on?
Under Section 31, one can see that that is a route for functions to be transferred to certain tribunals. And in fact, what one can see in relation to immigration is that all of the functions of the Asylum and Immigration Tribunal were transferred across to the first-tier and upper tribunal as of February 2010, and that was via the transfer of functions of the Asylum and Immigration Tribunal Order, which is at tab 6 of your...
So it's 31B, which is Lord Chancellor may by order provide for a function of a scheduled tribunal to be transferred to the upper tribunal.
My Lord, yes. And so, in the beginning, the upper tribunal was void. It didn't have powers. It didn't have functions or powers, and those functions were transferred to it from various different other places. And one way in which they came to it was being transferred under Section 31. And the functions that were transferred under Section 31 were the powers to determine asylum and immigration appeals, which had previously belonged to the Asylum and Immigration Tribunal. That isn't the only way by which a tribunal can accrue functions. And what I've pointed out in my skeleton argument is if one's looking for another route, one can see that from Section 32 of TCA, so two provisions on. So this is an example. I don't say it's the only example, my case doesn't depend on it, but this is an example whereby the upper tribunal will have the powers to be determining an appeal which has not been transferred under Section 31. And just to explain, Section 32 is dealing with situations where a function, one can see from 32.1a, a function's transferred under Section 31a in relation to England, but isn't transferred under Section 31 in relation to Wales, or a function that's not exercisable in relation to Wales is transferred under Section 31a in relation to England. In short, these are times where there's a 31 transfer in relation to England, but there isn't in relation to Wales. And in those circumstances, one can see from 32.2 that the Lord Chancellor can say that appeals ought to be, by order, can say that the appeals should be to the upper tribunal. So he can require that the appeals go to the upper tribunal. Now those powers haven't come via TCA Section 31, but the Lord Chancellor has, by order, given them to the upper tribunal. And in those circumstances, the Lord Chancellor wouldn't be allowed to exclude those decisions. And one can see perhaps why not. because this would be a situation where he's taken appeal rights that are there in Wales. He said they need to go to the upper tribunal. He can't then, by order, curtail those appeal rights and say that they can't that the appeal can't go on to the Court of Appeal. So that would be a perfectly good reason why section 13.9 is specifically talking about functions which are transferred under section 31.
I think that's the case, of vague memory, with leasehold valuation tribunals, which still exist in Wales, but whose functions in England are now undertaken by the first tier tribunal.
My Lord, I suspect that all of the advocates in this court aren't going to be able to search in that, and I apologise for that. But it makes the point, which is that it would be wrong to look at this, as Ms. Kilroy has made fairly the point, it would be wrong to look at this only in relation to immigration, because the draftsman of the TCA was looking at all sorts of different tribunals and trying to work out what might happen in all sorts of different circumstances. And so we're saying, for example, that the Lord Chancellor doesn't have the power by order to exclude appeal rights in relation to all of these other functions which might have come to an upper tribunal by another route other than section 31 of TCA. And there might be another route, for example, and I don't say that this needs to be decided upon, but judicial review. And the judicial review powers of the upper tribunal might also be another example, which weren't transferred under section 31 because they didn't come from another tribunal. But the upper tribunal clearly has the function to decide upon, of deciding upon judicial reviews. The point of section 39 is that the Lord Chancellor can't then say, by way of order, well, I'm going to curtail the appeal rights in relation to that. This is in our skeleton, and I don't want to take too much time. My Lord, if there's anything further I can add on that point.
Yeah. Right.
And then going on, then, my Lord.
Did the Lord Chancellor in fact exclude Rule 43?
Yes.
This is the construction of the statutory instrument, presumably.
It is, my Lord. And we say that in the first instance, this is clearly a procedural decision. We say that because, of course, as we've already covered, it's solely concerned with procedural issues. We say that as well because the Rule 43 power is given to the upper tribunal by way of section 12, so section 22 of the TCAA.
Sorry, section
22,
yeah,
which is page 8 in the Lordship's bundle. And that sets out that there are to be rules to be called tribunal procedure rules governing the practice and procedure to be followed in the first tier tribunal. So Rule 43 is a rule of practice and procedure.
but in fact it's the upper tribunal that you're looking at, which is B.
My Lord, yes. And indeed, I don't think there's any controversy. There can be no controversy, but the my learned friend makes the same point as to where the powers under the rules come from. Paragraph 32 of the appellant's grounds of claim, grounds of appeal. Now, the third reason why we say that it's a procedural decision is because, properly understood, it is a route to correct errors of procedure without having to go through the full status of appeal. It can normally be done as EP recognised on the papers. It can be done quickly. And its effect is limited. If the set-aside application is refused, then the original Rule 40 decision stands and can be appealed, including on procedural grounds. And therefore you stick with the status quo. So the set-aside application has done really nothing to affect the position of the parties. If the set-aside decision is granted, then the decision is going to be remade with that procedural error corrected. It gives the parties a fair second chance, but it doesn't affect their standing in substance between them. And the fourth reason we say that the decision is procedural is because that was the finding in the High Court case of AVB. If we can turn to that in the bundle, it's right near the back of the bundle. If I look at paragraph 29b. Says in application 29b, an application under Rule 43 of the rules is a procedural challenge to the upper tribunal's own handling of the relevant matter. Now, I don't hang too much on that because I concede that in this case, the nature of an excluded decision and indeed procedural decision clearly weren't fully thrashed out. The Secretary of State wasn't represented in this appeal. But it shows what other judges have believed this rule to be on first blush. It isn't the case, just to stress the point made in our skeleton argument, that matters which finally dispose of proceedings can't be procedural. For example, an unless order in civil proceedings, which says that unless someone serves a witness statement by X date, the case will be struck out. That would dispose of proceedings. It would still be a procedural decision for the purposes of looking at its nature. But in any event, the point made in the skeleton argument is that we don't accept that this does finally dispose of proceedings, because if one looks at how Rule 43 is described, it is described as setting aside a decision which disposes of proceedings, which again puts it as this subsidiary secondary decision, ancillary to the main proceedings, which is just trying to work out what is, whether the procedural failings mean that it should be set aside. Now, my learned friend has taken the court to a few cases this morning where there have been different definitions of procedural, of what procedural means. Can I take the court to Abiyat first? And that was handed up separately. We looked at paragraph 21 previously. I wanted simply to highlight for the court's purposes the sentence beginning in the third line. Mr. Mackenzie briefly submitted that a decision could only be procedural if it related to procedure in an appeal before the tribunal. I'm inclined to agree with that submission. Of course, this is an obiter remark by the Vice President of the upper tribunals. But insofar as one might question whether a Rule 43 decision relates to procedure in an appeal before the tribunal, the answer must be yes. My learned friend took the court to the VOM case, and paragraph 37 of that. I have that at page 87 of the bundle. It's just before the AVB case.
it's impossible to find your way around this with no pages and no tabs. So I'm looking, I've got to Jan, and it's after that.
It is, yes, it's penultimate.
Paragraph 32.
It's paragraph 32, yes, which is the last page of the judgment.
Yes. Yeah.
And this is the president, as what then was, looking at procedural, but says in the fourth line, these decisions are procedural because they're part of the statutory procedure prescribed by section 12. And then goes on to say, and do not finally determine the merits of the appeal. And as we've already seen, it couldn't be said that a Rule 43 decision finally determines the merits of an appeal. They either leave it as the status quo or they send it back to be reheard.
What kind of decision were they considering in this case?
It was a...
It's all very well to take these sort of statements without any context, but what were they actually talking about?
It was a decision to as to whether to remit after an error of law had been found, as I call it. And so the issue in this case, and subsequently looked at on appeal, was whether there is an appeal where the upper tribunal, there should be a right to appeal to the Court of Appeal, where the upper tribunal has decided there's been an error of law and is going to reconsider the matter itself. And the conclusion was that there wasn't, because the decision that there's been an error of law and to retain the decision to remake the decision was a procedural one, and that the appeal should come at the end of the process once the upper tribunal concluded it. A different set of circumstances would apply if there had been an error of law found and the matter had been remitted back to the first year tribunal, because the courts have found that in those circumstances the upper tribunal is functus officio. They have dealt with the matter before them, and there can be an appeal up to the Court of Appeal at that point because the matter has been finally disposed of. But what Justice McCluskey said was that these decisions, and they're not the same as this one, but they're procedural because they're part of the statutory procedure and do not finally determine the merits of the appeal. They're ancillary because they provide necessary support to the prime task of deciding appeal under section 11, an adjunct to the central and ultimate task of the upper tribunal. He then goes on to talk about preliminary. No one is contending that the Rule 43 decision is preliminary. But he then goes on to say this: if there were any doubt about their exclusion, we would pray and aid the same reasoning we've deployed earlier. If these are decisions, there's no good reason to interpret the 2009 order so as not to have them excluded. And there are very good reasons for interpreting the order as excluding them from any right to appeal. And then he goes on to make the point that my lady observed earlier on, which is the importance of interpreting these provisions in a way that doesn't undermine the processes in the upper tribunal, in effect. And so, in terms of any of these definitions, we say that this is a procedural or it is a ancillary decision. It's ancillary because it's not part of the core reason, core process for deciding an appeal, but it is a decision, a route which assists the tribunal in deciding appeals fairly. I'm going to, my learned friend hasn't taken the court to the case of ABB. That's addressed in the skeleton argument. We say it's wrongly decided. It is an unusual case in its facts, simply because the reality there was that someone had applied for set aside, their application being treated as an application for permission to appeal. The question was, what should everyone do in relation to that? and the High Court in that case simply hasn't engaged in the detailed consideration, as best we could tell, of these provisions that this court has. And look, I took you at the end of VOM to what I could call the purposive reasons for interpreting the order in the way that we say it should be. And that perhaps brings me to my learned friend's submissions as to the public purpose, or the public policy reasons why Rule 43 should have a right of appeal. And as I understand it, two reasons were advanced. The first was this situation where someone simply doesn't have appeal rights anymore and says they want to appeal, they want to bring a challenge under Rule 43. And the answer to that, I think, is this. It simply can't have been the case that when the statute was drafted in 2007, that what the draftsman was intending to cater for was some kind of situation which would, in effect, subvert the appeal timescales which have been laid down and give people a second bite at the cherry. If some individuals have made a mistake in other cases in relation to the time when they can appeal, then the remedy is to seek relief from the upper tribunal or this court for an extension of time to their substantive appeal. What would be wrong in my submission is to utilise the Rule 43 procedure, this shortcut, this procedural route, to try and reopen a right of appeal which they've lost. There can be no public policy which is the subversion of the proper conduct of the upper tribunal timescales and rules. The second point, which was raised by my learned friend, was in relation to the judicial review issue. And the question there was whether, as I understood it, there would otherwise be a number of people who are applying to challenge these kinds of decisions by way of judicial review. And the answer in relation to that is that if someone seeks to bring a judicial review under challenge to a Rule 43 decision, when they have the opportunity to proceed with a substantive appeal, it's likely that the Secretary of State will contend, and we say it's likely that the tribunal hearing the judicial review will find that the alternative remedy is to proceed with the statutory normal appeal route, and say that this is where the error of law lies. This is why the finding in my case should be overturned. It may be that that won't apply in every single case. It may be that, as my learned friend raises, there's a possibility that in some cases there won't be an alternative remedy of a statutory appeal. And if that is the case, then they might be able to challenge it by way of judicial review. But the normal route must be that they utilise the appeal route that they have been given to say, this is why things have gone wrong in my case, this is why there's been an error of law, this is why things should be overturned. And that perhaps takes me on to the merits of this case and the challenge to EP, because it might be sensible to set out at the outset what such an appeal against Rule 43 would amount to, Rule 43 decision would amount to. It could only be a decision that somehow the judge had erred in the set-aside evaluation. My learned friend says she's not encouraging this court to engage in the question of the evaluation of the judge of the interests of justice in the lower court, but that must be where such an appeal will end up. But the reality...
Well, assuming that Miss Kilroy is right, and that there is a right of appeal against a Rule 43 decision, we would have to find an error of law, would we not?
My lord, yes.
And I think Miss Kilroy said that, and suggested that was, so to speak, the filter on applications for permission to appeal Rule 43 decisions.
Yeah.
So there would have to be some serious point of law involved before you got permission.
Yes. But imagine perhaps that a Rule 43 decision was vitiated because it could be shown that an upper tribunal judge simply hadn't looked at a piece of paper which was in front of him or her. And therefore, in fact, they hadn't considered the set-aside application on all of the facts that were before them. The question is whether what one should do in those circumstances is quash their decision and put it back in front of them to have a look again at whether there should be a set-aside, or whether the reality is that by that stage, that process is finished and closed off to them, and they simply have to show an error of law which has been material to the outcome of their appeal, which means that that outcome should be overturned. And the purpose of the scheme, in my respect, this submission, is very much the latter. That the reality is that at the end of the day, once the procedural, and I'm still going to say I'm afraid shortcut, has not been open to a prospective appellant, they simply have to show the proper route, that there has been a material impact on their appeal so that, in effect, the wrong outcome has been reached. And so, my lord, we do say that that is the difference between the routes, but the alternative is that any appellant, prospective appellant, could push in an application to set aside, extend the time whilst that is considered, seek to appeal that. If there can be shown to be some kind of error, they go back to the upper tribunal. The upper tribunal then works out whether they should set aside. If they decide not to, then it goes on and on. And that simply isn't a system which could possibly be in the intention of those who drafted the statute or the orders. It would lead to delay and difficulties and costs on all sides, and simply wouldn't be in the interest of justice. So the public policy reasons that my learned friend advances simply can't get her home. To the contrary, we would reiterate what was said in VOM, which is that, in fact, the public policy goes in the opposite direction and does lead to an interpretation of the statute along the line that we have advanced this afternoon. My Lord, unless there's anything else, I'm just going to look briefly at my notes.
I wonder if I could ask something, please. And it arises from something that Miss Kilroy was discussing this morning with the court. Suppose there's a situation whereby the upper tribunal refuses to set aside. And the reason for doing so may be good. No, forgive me, let me start again. If the upper tribunal set aside a decision that's in the favour of this appellant or an appellant in these circumstances, the point she made was that the appellant who thought that he was home and dry in terms of having leave to remain would be deprived of that decision without any explanation being necessary, because you've taken us to the rules which say that no reasons have to be given, and that couldn't possibly be fair, which obviously therefore requires the ability to appeal in order to right that wrong. What do you say about that?
Well, Melly, it's for that reason perhaps that the set-aside process is so narrowly constrained, and it clearly is directed to situations where something has plainly gone wrong. That, for example, a document hasn't been received but ought to have been, or someone hasn't.
Understand that, but suppose that in this case it's not known on what basis the upper tribunal set aside the decision that gave permission to remain, because no explanation has been given. It's just set aside application successful.
Well, my lady, the reality is that in that situation, the statutory scheme does expect that the parties will have another go, but with a fair procedure. And it must be expected that...
I understand that. I'm sorry. So your submission is that there is no ability to appeal the basis of the Rule 43 determination?
Not by way of the statutory appeal. So in those circumstances, there couldn't be a statutory appeal up to this court. It is possible, and we certainly haven't excluded the ability to bring a judicial review challenge in certain circumstances. But what I've been hesitant about is trying to set out for this court an exhaustive list as to when that might happen, or even commit a tribunal to saying, commit this court to saying this can happen in these circumstances.
All right.
Because I can see that could lead to difficulties down the line.
So just one final question, Mr. Harland. Is there the ability of someone who suffers from the set-aside to ask why it's been set aside?
So in the AVB case, the court in that case considered the procedural fairness issues of reaching a conclusion without giving adequate reasons for doing so. And so whilst I've taken the court to the provisions in the rules which say there is no requirement upon a tribunal judge to do so, it certainly is entirely plausible that someone could say, in the specific circumstances of my case, this was such an abrupt U-turn from what was expected.
Even where there's no statutory obligation to give reasons, there's sometimes a common law obligation to do so.
My lord, yes. And again, being hesitant to commit future courts to anything, one can certainly see how that argument could be deployed. In fact, it has been.
Just following up my lady's question, if somebody applies to set aside a decision under Rule 43, presumably the other party is notified of the application, or is it an ex parte without notice application? What happens?
I'm just going to turn my back. I haven't seen anywhere anything in the rules which says that notice should be granted. I haven't, I'll admit, looked for that specific provision, but notice should be served or filed, and so there doesn't. Certainly, of course, if one looks at EP, one can see the tribunal case managing the matter in line with the overriding objective, which would be what would be expected on them. I can certainly conceive of other situations where someone writes in and says that the failure in my case was so gross that this needs to be set aside, and that the interests of justice might allow that tribunal to reach that decision without seeking representations. But again, we might be in the realms of procedural fairness and public law here, rather than the requirements that the tribunal rules require. I hope that's not too equivocal, but I think perhaps my answer in summary is the fairness of the situation is going to have to be managed by the tribunal, but what isn't anticipated is that case management then gets subject to its own appeal to this court.
That's all, thank you.
You mentioned in your submissions that you said that AVB was wrongly decided. What part do you say? I mean, I don't think it's material for us, but I just want to understand what you're saying was wrongly decided.
Well, there is a simple statement at I believe it's paragraph 24. The last 3 lines of that paragraph. whether viewed as a refusal to consider or as an implicit rejection of an application to set aside the 2018 decision, the 29 decision is not an excluded decision under section 13(8) of that act.
Does the judge give any reasons for that?
I don't. There's no careful analysis of the different arguments here. One can see from paragraph 19, so 3 pages before, that both the defendant and the interested party, so that's the tribunal, adopted a neutral position in these proceedings and did not appear before me, although each made the point in its acknowledgement of service. 29 decision.
I mean, 24 doesn't sit too easily with 29B when she says it's a procedural challenge. But anyway.
So the Secretary of State didn't turn up on this?
The argument that seems to have been advanced is that the claimant in this case was entitled to continue their appeal, so that because the upper tribunal judge has treated it as an application for permission to appeal rather than an application to set aside, the answer was that instead of bringing it by way of judicial review, that he should continue to challenge, or so she should continue to challenge what she said was a procedural unfairness by way of the statutory appeal. And the High Court, in fact, found in favour of the respondent, so the defendant in this case, in favour of the tribunal and Secretary of State, but for perhaps the wrong reasons. So having found it,
what did the Secretary of State put in submissions then?
Only all that I can see, and I haven't been able to obtain the pleadings, but it says the defendant and interested party simply adopted a neutral position that said that there was an alternative remedy, which is a statutory right to appeal to the Court of Appeal, which had not been exercised.
I see the judge in this case also dealt with reasons, duty to give reasons, paragraphs 34 and following. She does apply Dover District Council in CPRE case as a sort of common law duty.
In fact, I say that this was but that was the point I was making earlier, and this was the case I was hoping to refer to the court to.
Yeah. Right.
Very briefly, can I simply just look through these? Can I just tell me? Thank you.
Ms. Kilroy, do you wish to reply?
Yes, I'll go as quick as I can. Look, can I just start off by emphasising that this is about new powers that were conferred by the Tribunal Courts and Enforcement Act to set aside. And the question is, has a right of appeal, because of the structure of Section 13, been excluded? So it's not about people trying to circumvent rights of appeal or statutory time limits or having failed to exercise other rights of appeal. It's a simple question. When Parliament created the ability for someone to apply to set aside under what became Rule 43 but is described in paragraph 15 of the schedule, did Parliament also provide for a right of appeal against that type of decision to be excluded? And it's the appellant's submission, for the reasons that I've already been through, that Parliament did not exclude a right of appeal, having structured Section 13 in the way that I explained in opening, as conferring a right of appeal unless excluded. And so what is important when it comes to my learned friend's argument about the order is to be clear that the starting point is that Parliament did not exclude, and that's uncontrovertible, Parliament did not exclude a right of appeal in relation to decisions to set aside in section 13. It gave a power to the Lord Chancellor to do something much more limited than that, which is to preserve the position that had previously existed prior to the transfer of functions of the Asylum and Immigration Tribunal to the upper tribunal and first tier tribunal. So Parliament did not exclude the power, and the question is, could the Lord Chancellor exercise his power or her power to do so? And if so, has she or her done it in relation to this category of decisions? And so it's not undermining any scheme. All that this court would be concluding if it concluded that there was an exclusion was that this was carrying forward, this is the Lord Chancellor being permitted to and carrying forward an exclusion that pre-existed in the Asylum Tribunal. And because this is because there's no dispute between us that this is a new power that was conferred by the new Act, in my respectful submission, it is we start from a position, and I hear what my Lord says about the function and the decision of a description. I want to come to that, but we start from the position that this is not the sort of decision which would normally be within the Lord Chancellor's power, because it's an entirely new power conferred by Parliament. And you would have thought if Parliament, having said
it's a power conferred by the Tribunal's Rules Committee operating under powers given to it by Parliament.
Yes, but it already foreseen in the statute. And so that's important, just because some of the way that my learned friend put it suggested that this was an attempt to try and evade a scheme, evade time limits and extensions of time and so on, when actually what is really being asked is, has this lawfully been excluded? Was this part of a pre-existing restriction on appeal rights? And for all the reasons I've already explained, in my respectful submission, it is obvious that this was not part of a pre-existing system of reducing or excluding appeal rights.
It couldn't have been, you say, because the power didn't exist.
Because the power didn't exist. And so my learned friend says, well, there was no right of appeal because the power didn't exist. But it's clear from the explanatory note that is absolutely clear that argument does not work, because the explanatory note is about preserving a position where there were no appeal rights. Yeah. My Lord raised an important point about what is meant by a decision of a description. Can that mean that you have a broad description of the sorts of decisions that were excluded, but even though the type of decision that we're talking about here did not previously exist? And in my respectful submission, as I've already submitted, this broad category of procedural, preliminary and ancillary decisions, which is then specified, does not obviate the need to comply with decisions of that description. In other words, decisions of that type. It can't be within such a broad category. Otherwise, it would have been possible for the Lord Chancellor to posit a broad category, a very broad category, which it has in fact done. And even though the Parliament has knowingly and consciously created a new right of appeal to exclude, without excluding the right of a new power, but without excluding the right of appeal, and but for the Lord Chancellor to specify a broad category which has the effect of encompassing this new power and thereby to exclude an appeal right. And in my respectful submission, when you have a right of appeal which can only be taken away in restrictive circumstances as described, then the decision itself has got to be part of that previous system where there was no right of appeal. And so that is why, and when we look at the explanatory note, that point is clear. The second purpose is the preservation in cases where there is currently no appeal right of the existing position. And for those reasons, in my submission, it's obvious that this type of decision cannot fall within the power that the Lord Chancellor has. Wouldn't be preserving the existing position, he would be creating a new exclusion of a right of appeal which Parliament has expressly decided not to exclude itself. And my learned friend has then gone on to deal with the procedural issue and has referred to AVB. AVB, of course, does support the appellant's case. I accept that it wasn't fully argued, but as my learned friend fairly accepts, the Secretary of State positively posited in written submissions that there was an alternative statutory right of appeal, alternative remedy. So that was the Secretary of State's position in that case. But I'm not going to repeat the arguments that I made at length this morning about why it's not a decision, a procedural decision, just because it concerns a procedural issue.
Yeah.
And in my respectful submission, there hasn't really been an answer to that. And so those points, my Lord, really address the argument that was made by my learned friend about it being an accidental right of appeal. It's not an accidental right of appeal. It's a right of appeal that arises on the face of the statute unless excluded.
Yeah.
And again, it's not subverting anything. It's part of the system that was foreseen. Now, in the end, there appeared to be very little distance between us on the likelihood of this appeal right actually having to be exercised in most cases. We are agreed between us on this side and the Secretary of State side that it's unlikely to be necessary in most cases for this to be considered separately. It's unlikely to arise. And the circumstances when it does, my learned friend said judicial review, where there are, for example, real question marks about the exercise of the power. But, my Lord, the important point about this is that Parliament having conferred this power, it is obviously essential that it is exercised lawfully. And the question that my lady put to my learned friend highlights that. If there is a serious error in the decision to set aside, or indeed not to set aside, it must be capable of a remedy. Parliament has not foreseen that this power can be exercised in an unlawful way, even if it is intended to provide a backup or a swift method of disposing with an appeal.
I'm not sure that takes you very far, does it? Because we know that there are a variety of decisions which are excluded decisions, even though they are decisions taken in exercise of powers. So the blanket submission that where Parliament creates a power, it must be used lawfully, may be right as a broad generality, but it doesn't follow there's a right of appeal, because Parliament has undoubtedly excluded some kinds of decision expressly, never mind giving the Lord Chancellor powers to exclude more.
Well, I accept that, my lord, but most of those decisions, I haven't looked, none of the other excluded decisions in that list apply to the upper tribunal in this context, except in circumstances where they are going to be challenged in the course of other proceedings. So some of them I can't comment on because they are in tribunals that, and I am afraid I haven't examined how the lawfulness of those decisions would be assessed. But for example, it is right, so a decision of the upper tribunal under section 10 to set aside an earlier decision of the tribunal is an excluded decision. That would then lead to a new appeal, and it is right that I accept that could lead to an unlawful, it could be unlawful, and it would have to be challenged by way of judicial review. So I do accept that point. But all of this points to the need for careful and strict construction to ensure that what Parliament had in mind was certainly to exclude this right of appeal in respect of this particular decision, because there can be no doubt that there has to be supervision of the exercise of powers that are conferred by Parliament. And in most cases, it would be in a truly procedural, ancillary and preliminary decision, as was the case prior to the transfer of functions. Those decisions would be capable of being challenged in the course of the main appeal. Whereas this decision, which post-dates the appeal, it's only capable of being challenged either in the way that the first route that I mentioned this morning, if it is considered together, or separately. And in the absence of a right of appeal, the only method is judicial review. And so, in my respectful submission, all the pointers are that in the very unusual circumstances in which it is likely to be necessary for these appeals to be considered separately, which has not arisen until now, it should be via this route rather than a judicial review. My Lord, just one final point on the social security regulations. Of course, I think as my Lord Justice Dingemans pointed out, there has not in fact been an exclusion in relation to Rule 43 in that context, because the Article 3M of the order only excludes, if my learned friend is right, would only exclude Rule 43 decisions in this context. That article is applicable right across the tribunals. It's not bespoke to asylum and immigration appeals. So as things stand, if my learned friend is right, the Rule 43 conclusion in a social security case, it appears, is not excluded. Whereas if a Rule 43 decision is assessed to be a procedural, ancillary and preliminary decision, it is excluded in the asylum and immigration context. And that is a further reason.
Oh, I thought he was saying the opposite. I thought he was saying it is excluded in the social security context, therefore it ought to be similarly excluded in the asylum and immigration context.
Yes, but it isn't. He's wrong about that, because
I thought you said if he was right.
No, in the course of when I was on my feet this morning, I realise that, as my Lord Justice Dingemans put to me, and I think you my Lord, also, that Article 3M does not apply to decisions in that tribunal. It only applies in this context. So you can see that from from M.
Yeah.
Made in relation to an appeal under Section 40A, Section 82, or Regulation 26. So in fact, there is no such exclusion. If we go back to Section 13, there's no such exclusion of a right of appeal in relation to Rule 43.
Yes.
Well, look, can I just raise on that point, because my point may have been misunderstood. It's not that the Social Security Commission's regulations now fall under the upper tribunal rules, so that we're looking at an equivalent of Rule 43 there. The reality is that the regulations only exist in a very limited sense now, and not within the upper tribunal system. So I was raising it only for the point that I made earlier, insofar as what the draftsman would have been aware of. I'd urge the court, and I'm only getting to my feet because I fear that it's being thought that I was making a point that I wasn't earlier on. I wasn't suggesting that this is an ongoing situation within the tribunal system.
But my Lord, what it does mean is that the only rule, if my learned friend's submission is right, the only Rule 43 decisions that are excluded are in relation to immigration and appeal decisions, if it falls within Article 3M. I mean, my primary submission is it doesn't, but if it does, it's only been excluded in this context. And that is a further reason why, in my respectful submission, caution should be exercised in interpreting Article 3M and Section 13(9)(b) as permitting the Lord Chancellor to do something special in the immigration and nationality context, which he's not, in fact, has not done in any other context.
Although it might fairly be noted that there's a completely different volume of appeals from the two jurisdictions.
Well, it might, but the reality is that this has, your Lordship has said that, but this issue has not arisen before.
No.
And so we are talking about something very unusual. What Rule 43 is working in this sense. It is a safety valve, as it were. It's an opportunity for the tribunal to do something of its own motion, to fix an appeal that has gone wrong. But that power is amenable to appeal on the face of the statute. In extremis, in an unusual situation where it is necessary to do so, a right of appeal ought to exist. And there's no reason why it should be excluded when that new power has been made available and was not subject to any restriction prior to the transfer of functions. So, my Lord, I don't think there is really anything else that I need to reply. I mean, obviously, AVB supports the appellant's case, but the primary arguments in favour of the appellant's case are based on the construction of the statute itself.
Just one question. In the proceedings below, your client's name wasn't anonymised in the Rule 43 proceedings. Your client's name has been anonymised under the practice direction here. I imagine that's what you would ask to continue, is that right?
Yes, I don't know why that hasn't happened, and I think that is a mistake because it is an asylum claim, so it should obviously have been.
Well, that's what it. I mean, that's certainly what the practice direction provides for you.
Yes, that's an error.
Thank you.
I'm very good.
Right, well, thank you both very much for your interesting arguments. It's a tricky little puzzle, so we will reserve our judgments. You'll get a draft in the usual way, which will be your opportunity to correct our spelling and grammar, but not our reasoning. We would hope that in the light of the draft judgments you will be able to agree a form of order disposing of the appeal. The draft judgment, as you know, comes with a beefed up embargo, which means what it says, It is not to be disseminated except for very limited purposes before actual hand down. When we have received your comments on the draft, we will arrange a hand down, and if you can't agree a form of order, please make short submissions before hand down, and we will make the form of order we think is appropriate. Thank you very much.